law school, our ethics professors told us not to steal from our clients and to put their money into a trust account. But protecting client funds is more complicated than that. Meeting our ethical obligations takes more than good character. It takes work. If you don't know what you're doing, you can quickly lose control over client funds, violate the rules of professional conduct, and face serious sanctions. We need to know how to open an IOLTA account, how to use it. We must watch our withdrawals. We can't rely on our memory. We must maintain solid records, reconcile our account every month, ensure that our bank has handled the funds correctly, check our checks, and keep our records. You'll need to open what we call an IOLTA account. That stands for Interest on Lawyer Trust Accounts. One account should be enough to hold all of your client funds. You don't need to maintain a separate account for each client. Not every bank can open such an account. You need to visit a bank that participates in the IOLTA program. But even some participating banks may look puzzled when you ask to open an attorney trust account. If they do, take your business to someone who knows what they're doing. After all, you're responsible for opening the right type of account. Most banks waive maintenance fees on IOLTA accounts, but since client funds may not be used to pay bad check charges, fees, or other incidentals, the bank isn't allowed to deduct such expenses from the account itself. Once opened, all checks and deposit slips must clearly designate the account as an attorney escrow account, attorney trust account, or client's funds account. Client funds go into your trust account. Your funds go into your operating account. Sounds simple, but lawyers often commingle their clients' funds with their own. In a busy firm, it's easy to grab the wrong deposit slip and accidentally put your own money into escrow or your client's money into your operating account. Keep deposit slips, checks, and other materials pertaining to your trust account in a separate location from those pertaining to your operating account. This lessens the likelihood that you'll confuse the two. When you get money, you must first determine who the money belongs to, complete the correct deposit slip, and place it in the right account. When a client pays you for services you already rendered, that money belongs to you. That goes into your operating account. If a client is reimbursing you for expenses you already incurred, for example, filing fees that you advanced for the client, if you're getting reimbursed, that's your money. That goes into your operating account. Retainers to cover future legal fees and expenses. That belongs to the client, and until you've earned it, it stays in IOLTA. The same is true for flat fees for work that you still have to do. Remember, fees are never earned upon receipt. If you still have work to do, that money belongs to your client, that money goes into IOLTA. Settlement checks. A large settlement check actually belongs to various people. Remember, your fees will come out of that check, certain medical liens have to be paid, other expenses that you've advanced, and the rest goes to the client. But until you've identified what all those disbursements are and are ready to disperse, that settlement check goes into your IOLTA account. The same is true for disputed fees. If you have a fee dispute with a client, the client thinks that you've overcharged and you haven't earned certain fees and that has to all be sorted out later, well, until it's sorted out by arbitration or some other method, it stays in IOLTA. At least the disputed portion stays in your IOLTA account. For settlement checks, say you settle Fred's accident case for $10,000. Put $10,000 into escrow. Pay off any liens or expenses for your client. Take your 1/3 fee of $10,000 and recover any expenses that you've advanced, and pay your client the rest. Once you earn your fee, take your money. If you let your money sit in the trust account, that will amount to unlawful commingling. Beware of the following. Cash disbursements. When you write checks on the trust account, you must properly designate the payee so that a proper paper trail may be preserved. So if you write a check payable to cash or to bearer, you're breaking the law. ATM withdrawals. If by mistake your bank gave you an ATM card for your trust account, cut it up and inform your bank that cash withdrawals or debit card payments are not allowed. Borrowing. It's not your money. So borrowing funds on a rainy day to cover firm expenses or other personal bills is theft. That will cost you your license. Overdrafts. If the disbursement would create a negative balance with regard to an individual client matter or to all client matters in the aggregate, something has gone drastically wrong with your accounting. Even if other client funds are sufficient to cover the check, you can't use one client's money on behalf of another. Take an account which holds a total of $30,000 in funds belonging to Mo, Larry, and Curly. If I get a $30,000 check to settle the case of another client, I must wait until that check clears before I may disperse the proceeds. If I disperse too early, I'm using other clients' money to cover disbursements in a totally different case. That may prevent an overdraft, but you have effectively misappropriated someone else's funds.
And what are you disturbing the court for?
Don't disturb the court or bar counsel. If you overdraw your account, the bank must report the deficiency to bar counsel. Even if the bank lets you draw on an available balance, which includes checks that have yet to clear, you can't draw on funds until they've been collected by the bank. I'm absolutely paranoid when it comes to ensuring that checks clear before dispersing the funds. Unless the money is actually there, you can't draw on it, period. When accounting for client funds, the only memory you can rely on is that contained on your computer. There are lots of great computer programs that will help you organize ledgers of trust activity. Mine automatically updates these records whenever I write a check or make a deposit. When you write a trust check, these programs instantly record the client, matter, payee, date, check number, and purpose of the disbursement. When you print a deposit slip, these programs will keep tabs of the date and purpose of each receipt, the client's names, and the matters to which they pertain. All of this data will instantly populate up-to-the-minute trust ledgers, client ledgers, and a host of other reports that you can print at the push of a button. It's much harder to do all of this by hand. In this day and age, handwritten ledgers and manually written checks are unnecessary and unnecessarily risky. Only a legal dinosaur would keep handwritten records. And if you lose track of your trust account, you and your license may also face extinction. You may not intend to steal from your clients, but careless accounting may lead to misappropriation and harm them just as much. To protect your clients, you must keep two types of ledgers. The client matter ledger. This shows all trust transactions on each case. The overall trust ledger shows all transactions on all cases. The client matter ledger. This gives you a snapshot of all trust activity for a given client in a given case. On April 1st, Victim's Personal Insurance Company sent a PIP check for $1,000 for medical treatment. Since that's the first check received into escrow, our IOLTA balance is $1,000. May 15th, Tortfeasors Mutual sent a settlement check in the amount of $10,000. That increases the IOLTA balance to $11,000. On May 30th, we're writing our first check out of IOLTA. It's to Chesapeake Chirohackers. Check 123 is for $1,000 for treatment of our client. That reduces the balance to $10,000. And out of that $10,000, on the same day, May 30th, I'm getting paid. Check 124 to Kramer and Connolly for $4,200. That'll account for my 1/3 fee plus all the expenses that I advanced during the course of representation. That reduces the balance in escrow to $5,800. Where does that go? Right into our client's pocket. On May 30th, we write check 125 to Curly DeStooge as net recovery to the client in the amount of $5,800. If we've done it right, at the conclusion of this case, our client matter ledger will be reduced down to 0, and that's exactly what it shows here. You're allowed to pool all of your client's money into one trust account, but without allocating specific funds to specific clients, you won't know who has what. You won't know that the $10,000 check represents the gross recovery in Curly DeStooge's case, or how PIP payments from his own insurer were allocated to medical providers. This is an extremely simple auto accident case, but without the right ledger, you'll lose track of even the simplest case. Don't think you can rely on memory to keep this straight. As your practice grows, you'll quickly lose control of your account and won't know which funds pertain to which cases. The same data on your client ledger will show up in your overall trust ledger. This shows all deposits, disbursements, checks, payees, and the clients and matters to which they pertain. Our ledger for the month of May shows transactions for all 3 of our clients, Mo, Larry, and, of course, Curly. We'll reconcile this report every month with our bank's account statements to catch mistakes. This is one checkbook you must balance. To do so, you must carefully compare your bank statement with your trust ledger each and every month. Let's compare our trust ledger with our bank statement for the month of May. Wait, this is showing a balance of $22,000, but our ledger only shows half of that amount. We're missing $11,000. Don't be alarmed. Your bank statement will rarely match the figures on your internal ledgers. Why? Because the monthly bank statement won't show checks or deposits that have yet to clear. To balance the two, we need to make some adjustments. Here's how in 6 easy steps. Are checks and disbursements missing? What's the total of unlisted checks and disbursements? Are some deposits missing? What's the total of unlisted deposits? Add missing deposits to the bank's reported balance. Subtract missing checks and disbursements from the bank's reported balance. Let's take these steps together by preparing a reconciliation report. Are checks missing from the bank statement? The bank shows only 1 check for May, but our ledger shows 4. So we need to list the missing checks on our report. Are deposits missing from the bank statement? The bank reported 2 deposits for the month, and that matches our ledger. So there are no missing deposits. Now we're ready to reconcile. We start with the balance reported on the bank statement and adjust that balance by adding all unlisted deposits. Here there aren't any to add. We must also subtract all uncleared checks. Since $11,000 worth of checks have yet to clear, we subtract these checks from the bank's balance to get an adjusted bank balance of $11,000. If we've done it right, our adjusted bank balance will equal the balance contained on our trust ledger. This is what our monthly reconciliation report should look like. If you complete this form each and every month, you'll be reconciling your account and ensuring that all client funds are accounted for. I know you just don't have the time to balance your checkbook. That's fine. It's your money. You can rely on your bank if you wish. But the funds you hold in trust don't belong to you. They belong to others, clients who are trusting you to protect their money. So you can't leave that responsibility to your bank. Banks do make mistakes. They aren't supposed to charge fees or to debit your client's funds to cover account expenses, the printing of checks, or bad check charges, but these mistakes are quite common. If you don't catch these errors and overdraw the account, the bank will still report the overdraft to Bar Counsel and trigger an audit of your entire account. If you don't want Bar Counsel reading your account statements, you must read them yourself. Remember, it's your professional responsibility and your license. You can't trust your bank with either of them. There are 2 critical times to check your checks: before you send them out and after they come back. In the hectic pace of our practice, we might grab the wrong checkbook, pay firm expenses with a trust check, or disperse trust proceeds with a check drawn on our operating account instead. We may also confuse these two accounts when depositing funds. These errors may overdraw our IOLTA accounts, get reported to Bar Counsel, and prompt further investigation. To prevent these mistakes, keep your checkbooks in different locations within your office. Print your trust checks in a different color and style from checks designed for your business account. And while this isn't always practical, it would probably be a good idea to use separate banks for each account. Anything that makes it harder to confuse these accounts will reduce errors and inadvertent infractions. Later on, when your bank sends you copies of canceled checks, you must exercise similar vigilance in checking your checks. When you get your bank statement, you'll get a copy of an array of canceled checks. Take your time to examine them. Does anything seem out of place? Check 321 sticks out like a sore thumb. This April 1st check is out of sequence. It's dated earlier than the others, but has a later check number. In fact, the signature looks fake. Mr. Murphy's signature on the other checks is quite different, and our forger doesn't spell very well. Even if it were genuine, it's made out to cash. That's a big no-no. And what about check 121? It looks like your signature, but you're paying to press suits. These aren't lawsuits. This is dry cleaning. You can't pay personal expenses from client funds held in trust. This is probably a mistake. Somebody grabbed the wrong checkbook and it came out of escrow in error. You can catch these problems, but only if you check your checks for items out of sequence, forged signatures or checks that seem different, improper endorsements, unfamiliar payees, checks payable to cash, and your own mistakes. This is an essential way to protect yourself and your clients from fraudulent transactions and other serious problems. I know what you're thinking. I'm a lawyer, not an accountant. I don't have time to do this each and every month. Perhaps you'd rather do it on a quarterly basis. That won't suffice. Why not? The rules require that you do this each and every month. If you don't, you're breaking the law. And if Bar Counsel asks you for ledgers and reconciliations that you just don't have, prepare to be sanctioned for misconduct. Protecting your client's funds takes more than honesty. It takes care in opening your IOLTA account, using it wisely, watching our withdrawals, forgetting about using our memory, keeping meticulous records, reconciling our account each and every month, reviewing our account statements carefully, checking our checks, and keeping our records. If you neglect these tasks, you place more than your client's money at risk. You'll place your license and livelihood in jeopardy.